Ms. Karen Groff, she practices internationally as counsel, attorney at law, arbitrator, educator, and ADR neutral. Hi, Karen.
Well, good morning from a rather miserable London, which is quite contrary.
Thank you so much for
what I'm
for
sure
talking
you've
to
all
us.
read in the newspapers. It's very grey and overcast here. Good afternoon to you in Hong Kong, and greetings from London. I was just listening to Robert Gateskill, actually, and I was obviously interested to hear what he had to say. And the war story thing is something we can all relate to. I have to say, nobody likes a hired gun when it comes to experts, and a really salutary tale is when I cross-examined an expert in a case once over a defective roof. It was a historic building, and he said the roof was marvellous, it was great, there was nothing wrong with it whatsoever. So I got my client to bring some of the tiles from the roof into the court hearing, and the judge looked slightly bemused, but I handed up this tile and I said, well, sir, what do you think of this tile? Is this a tile that you would actually like to see put on a roof? And the tile was shocking. It was all shaly and falling to pieces. And he looked and said, well, no, of course not. And I said, so it would be a surprise to you then to learn that this is just one of the very many tiles that we've had to take off this roof. And the judge didn't say, I think this case will settle, but within the hour it did. So nobody, for a hired gun, you never do anybody any favours. Anyway, I digress. Let me go back to my own topic. Thank you for inviting me to join you today to speak at your conference. Regrettably, I also appear remotely, but I hope in the near future that I will be able to join you and others in person. My topic for this afternoon is mechanisms to deal with unforeseen, unprecedented, I can see there's going to be a trouble, contractual impacts. Only 3 years ago, we may have discussed something like unforeseen ground conditions not revealed by site data, or the discovery of unforeseen contamination in the subsoil, either or both of which may have prompted claims which would have been resolved by reference to the form of the parties' contract and the allocation of risks between them within its terms. We had a roadmap then. We had a contractual machinery to manage and resolve the resulting disputes about liability for the time and cost consequences of them. There were disputes, but decades of work, and I mean decades of work, into the development of contract administration tools, dispute avoidance processes, and dispute resolution mechanisms, provided a framework for parties to resort to so as to manage, avoid, or resolve their disputes. And what I'm going to look at is the extent to which this was effective, obviously by reference to the pandemic, but also by reference to the tailwind of the pandemic, because today around the world, contractors and owners face huge challenges getting their projects out of the ground and into being. Graham is panicking because I haven't yet shared my slides, so I'll do that, but I wasn't about to refer to them yet. But hang on. Share screen. There we are. Right, so let's share the screen. What's that doing? My apologies. Hopefully you can see my slides. Good. Sorry about that. Okay, so as I was saying, contracting before COVID, obviously I've done some introductory slides, and the first, always begin at the beginning, is my motto. What are the options? I mean, I assume that are mostly engineers, lawyers, and people who pretty much understand the basic methods of contracting, which parties are likely to employ. And we have the traditional method, design and build, and turnkey. There are others. And then this choice of option of contracting dictates really the allocation of risks between the parties. And this is central to what I'm going to talk about, or what I am talking about this afternoon. And you will understand already that the traditional methods of contracting allocate the majority of risks onto the employer, obviously the risk of construction onto the contractor. You can have a contractor's design portion, which sees a greater sharing of the risks. You have a design and build option. You have greater control by the employer, more so than in a turnkey contract, and that of itself carries associated risks. But design and construction risks are basically moved over to the contractor. And then a turnkey contract where the entirety of the risk, or certainly the vast majority of the risk, is intended to be shifted to the contractor. And depending on what form of contract you're in, of course, when you have an unforeseen or an unplanned event, then you understand where the risk is likely to fall and your options. Taking risk allocation under FIDIC has a general principle, and FIDIC has been pushing this mantra for decades. I don't know whether contractors and owners have been deaf to it, but frankly, if people had adhered to it, people like Robert and I wouldn't be in work, or certainly we'd be in a lot less work. Generally, FIDIC says, apportion the risk to the party best able to carry it. That's a very simple proposition. Why should it be so difficult to achieve? So traditionally with the Red Book, you see that it's substantially on the owner, for construction on the contractor, and then the Yellow Book, design risk shift to the contractor, but owner still carries substantial risk. Turnkey, Silver Book, and the very many modifications of that, some of them too awful to talk about. Minimal employer risks, or certainly substantially less employer risks, and the intention is to shift the risk to the contractor. So let's move on to unforeseen issues, certainly pre-COVID. I mean, one of the great unforeseen issues, and certainly in infrastructure projects, is going to be difficult ground conditions, unforeseen ground conditions, contamination, obstacles within the ground that the contractor's going to say they simply weren't foreseen. And certainly the English jurisprudence is really quite clear on the point, although it could sometimes, I say, be perhaps a bit of a lottery, depending on the judge you get, as to what any individual judge would regard as unforeseen. There's always an element of discretion in making that determination. But difficult ground conditions, a great example is the case of Obrascon, Huarte Lane, and the Attorney General for Gibraltar. I think one of my colleagues was on the losing side of that, but not to worry. But what the Court of Appeals said in that was that the contractor cannot simply accept someone else's interpretation of the data and say that that is all that was foreseeable. So in that case, the contractor argued that the ground condition was unforeseeable because the environmental statement supplied by the employer at the tender stage contained an estimate of contaminated material which was much lower than the levels of contaminated material which were actually encountered on the site. It was only after the contractor had commenced its work that the contractor appreciated that the estimate was wildly wrong. The contractor claimed and contended that it was entitled to rely on an environmental statement which was primarily directed to planning matters. And some of you may think, what? And certainly I've had a similar experience where reports have been prepared for planning matters and then they've been used by the employer, certainly as a starter for 10 for the ground conditions, and then everything gets out of hand, everything goes too quickly. And if the contractor wants to carry on, they're just going to have to go make their best judgment on the report they've got rather than use their own, secure their own report and get more detailed information. So in this case, that seems to be what happened, and the contractor contended that he was entitled to rely on this rather odd planning environmental statement. The Court of Appeal, both the judge at first instance and the Court of Appeal, held that the estimate in the environmental statement was only one person's interpretation of the ground information data taken from the site. Under clauses 1.1 and 4.12 of the FIDIC conditions, the contractor was also required at tender stage to draw upon its own expertise and experience of previous civil engineering projects and make its own independent assessment of the available information regarding physical conditions on the site. I think at this point, we should also talk about clause 4.10 just briefly, because 4.10 of the FIDIC conditions puts responsibility for interpreting site data on the contractor. And I must say, from experience, these claims are rejected more often than they are accepted on the basis that the contractor should have exercised greater judgment and should have carried out some further investigations itself, particularly if the information was patently lacking. So slide 6. This is, I'm introducing the concept of the experienced contractor, and the cases refer repeatedly to experienced contractors. And the standard forms of contract, when being used, they all apply an objective test of foreseeability of difficult physical conditions. In the experienced contractors price and programme, and the Van Ord case is about that. Is it also a FIDIC case? In Van Ord, the contractor made 3 disruption and prolongation claims against the employer arising out of an onshore gas pipeline laying contract in the Shetland Isles. One of the claims related to alleged unforeseen ground conditions, in that numerous instances of the presence of peat, which is not uncommon in the Shetland Isles, I have to tell you, running to quite a depth, impacted the contractor's planned methods to carry out the work. The contractor's original plan was to build a stone road 8 metres wide, then dig a trench into the untreated ground beside the road and lay the pipeline in the trench, which is fairly straightforward. However, because peat was encountered over a section of the works at a greater depth, the ground conditions were unstable. The contractor said the depth of peat was more than it could reasonably have foreseen. And the unstable ground conditions obliged the contractor, in fact, to build a 13.5 metre wide stone embankment and lay the pipe into that. The contractor obviously claimed the additional costs of building the stone embankment rather than the stone road. The court held it was not sufficient for the contractor to show that there were pockets of peat deeper than those shown in the probe survey provided at tender stage. The court would need to decide objectively whether or not an experienced contractor could reasonably have been expected to have foreseen and provided for areas of deeper peat. The Court of Appeal decided in Van Ord that an experienced contractor could reasonably have been expected to foresee many pockets of deep peat along the pipeline. the contractor was rather shot down by one of his own witnesses, who, under cross-examination, agreed that that is exactly what he expected to find, many pockets of deep peat. So, right, let's go to the next slide. The experienced contractor, oh yes, here, I'm referring to NEC 4 and clause 60.2. The thing about NEC is it explains so much more than some of the other contracts. And that's saying something when one looks at the size of the FIDIC 2017 forms. But NEC 4, if it says something, usually gives an explanation as to why it's the case or how it is that you meet the criteria. And this is just the same in the case of unforeseen circumstances. At core clause 60.2, that's explicit about the material the contractor is assumed to have taken into account when bidding for the works. Now, the site information, well, as we've just seen, that's usually the cause of the problem. Publicly available information referred to in the site information. And sometimes you may have a report prepared for planning purpose, but it may refer to a number of other documents. And very often contractors don't follow that paper chain, don't ask for that information, and they can quickly get themselves into a problematic situation. Information obtained by a visual inspection of the site. Well, if you're worrying about ground conditions 10 or 15 feet down, a visual inspection's not so likely to be of much assistance. But the last one, I think, is the catch-all, and that's other information which an experienced contractor could reasonably expected to have or to obtain, and that is my emphasis, or to obtain. The problem far too often is that contractors are pushed into bidding at speed and they don't have time, or they're told not to bother, and they take the risk. They fail to obtain site reports which are in line with their proposed designs for the works. So they simply don't discover these things. And of course, any existing reports, they are only good for the places in which the tests have been made. In NEC, I'm drawing your attention also to clause X2. This is one of the optional clauses and changes in the law, obviously particularly relevant in the case of the pandemic. It's a change in the law in the country in which the site is located, and it must occur after the contract date, obviously. And if there is such a change in the law, it will amount to a compensation event. And finally, with NEC, I just draw your attention to the potential for owners to alter risks via the Z clauses, the bespoke clauses, which they themselves will add into the contract. So during COVID came, legislation was enacted in many jurisdictions around the world to manage some of the obvious impacts of the pandemic, including government measures limiting the ability of individuals and companies to go about their ordinary business. Unprecedented, I would call that. Construction and infrastructure projects were suspended the world over, and in some countries they were suspended for a very long time. So this is a list of some of the issues that would have arisen as a result of COVID. Well, how does FIDIC deal with this? FIDIC, with the red and yellow book, has clause 8, and I'm referring to the 2017 forms now. It's easy enough to go back to the 1999 forms, but I think in 2022 it's appropriate to use the 2017 forms when talking about these things. So clause 18, exceptional events, previously force majeure. The contractor would be looking for an extension of time and in some cases recovery of costs, but not in every case. Clause 8.5d, unforeseen shortages in availability of personnel or goods. or employer-supplied materials due to epidemic or government actions. I'm sure contractors were very pleased to see that clause when they actually got down to the fine detail. Clause 8.5e, delay caused by the employer, less so. Clause 8.6, unforeseen delays by authorities, and this really is more a reference to statutory authorities, but when we were in the pandemic situation, authorities, like every other organisation, seemed to me to simply shut up shop, and getting anything out of anybody was very, very difficult. So it's quite foreseeable that a contractor may have suffered unforeseen delays under that clause. And then changes in the law, clause 13.6, changes in the law affecting costs. Now, FIDIC, shortly after the pandemic hit, issued its COVID-19 guidance memorandum to users of FIDIC standard form contracts, and they published it in April 2020. And given the time when the pandemic started, that was pretty swift. They were pretty quickly out of the blocks with this guidance, and it really was quite a useful document. And within the guidance, they said, FIDIC's core purpose of drafting this guidance memorandum is to help parties to a FIDIC contract to consider mutually satisfactory solutions, avoid disputes arising between them. COVID-19 pandemic is a unique, broad-scale and extraordinary event which should be recognised as such. It therefore fits neatly within the scope of this talk, this presentation. But not everything fitted neatly into a contractual provision. Not all of the impacts of COVID fitted into the contractual provisions, and parties had to manage a number of impacts which were simply not dealt with by the existing contractual machinery. An example I'd like to just mention to you arose when Trinidad closed its borders at the outset of the pandemic. It basically shut down its construction industry. I was told that everything stopped with the exception of one major road. All construction work on the island was mandated to stop, and in the event, that suspension went for more than a year. So clearly under the standard forms, and FIDIC read the yellow books I use quite substantially, in Trinidad, circumstances arose which would have enabled either one or both parties to have brought the contract to an end. The issue here was substantial numbers of immigrant workers were effectively marooned in Trinidad. It closed its borders, so these people were marooned on the island. They could not work, they could not leave, and all the time they were effectively locked down in Trinidad, they had to be sheltered and fed, but the works were suspended, and there was no obvious right for that cost to be visited on the employer. In addition to that, project costs soared. Obviously, the health protocols, that's the same for all of us around the world, great layers upon layers of additional cost, transportation of labour, everything became so much more expensive. And then as the pandemic prolonged, unavailability of materials, supply and demand pressures, shipping and distribution delays, additional project overheads, foreign labour, local staff, site security, and then of course things like extensions of bonds and guarantees. So what happened in Trinidad? Well, extraordinarily, what happened was no contracts were terminated. Employers bore the brunt of the financial burden and of course the delay, and projects at the end of the suspension resumed and actually went forward for completion. And so, how did that happen? Clearly, the size of the contracting organisation impacts its ability to survive the impacts of the pandemic and to restart and complete projects. but by working together, the worst impacts of the pandemic were averted. In the event, record keeping was key to providing records and data to support contractors' inevitable claims for costs, and adapting to the changed working conditions on site when they were allowed to go back to site as the industry reopened. But in order to avert and to deal with these unprecedented issues, the parties needed to be creative. And in the case of no-fault impacts, contracting parties always have the option to collaborate and agree on non-contractual solutions to issues not covered by the strict contractual mechanisms. So parties were in the position of having to consider their priorities. Optional termination, payment and release appeared not to be a preferred route. And what parties sometimes forget is they always have the right to assume, to choose another option. And as I say, optional termination, payment and release was not the preferred option. The preferred option was to complete the projects that had been started. So in some cases, employers and contractors collaborated to assist stranded workers in obtaining state relief, and even fluctuations claims, which had been struck from contracts, were effectively reinstated gratis, so that the contractor would recover at least some of the costs, additional costs that were incurred. And in order to determine those costs, the parties fell back on their record keeping. And so the availability of contemporaneous records was absolutely imperative. It's always imperative. But during a situation like a pandemic, it became particularly critical. I'm also told that on one project, a FIDIC engineer instituted a shared system to monitor the contractor's record keeping as to the effects of the pandemic as it wore on. So that really is a happy tale. And when I was talking to somebody in Trinidad about all these things, I said, do you think that will continue after the pandemic? Do you think parties will continue to go down that road and to look for constructive commercial solutions? And she said, no, almost certainly not. That wasn't quite so encouraging. Anyway, this is the provisions in the FIDIC Silver Book, which I just added completeness. I don't need to carry on with that. And now NEC4. What are the provisions in NEC4 to deal with unprecedented issues? What does clause 60, which is the clause that deals with compensation events, which permits extensions of time and recovery of costs, what does that give us to help with these unprecedented events? One thing about NEC4 is that your chance of recovering costs as well as time are greater than under FIDIC. But anyway, look at the clause 60.113, and you have adverse weather. And the adverse weather claim is objectively determined by data, and the key test is the occurrence is likely less than once every 10 years. So that speaks of pretty serious weather conditions before you would actually have a compensation event. The pandemic clause really, I think, is generally accepted to be clause 60.119, which is known as prevention, which I think is NEC's force majeure. Events which prevent completion or delay it, and neither party could prevent it, and an experienced contractor would have judged the risk of it happening to be so small as to make it unreasonable to allow for it when bidding for the work. And the other clause I mentioned just a few minutes ago, X2, concerning changes in the law. So, by way of general comment, I think it looks at first sight, when you look at the conditions of these contracts and existing jurisprudence At first sight, the terms of the standard forms of contract are capable, at least in principle, of dealing with the impact of unforeseen physical conditions and including exceptionally inclement weather. I think FIDIC, whilst it doesn't have exactly the same sort of structure as NEC, and a structure of the adverse weather clause, it calls it exceptionally adverse climatic conditions. And again, in FIDIC, it's determined by reference to data. And with generous interpretation, also with unprecedented events like the pandemic, I say generous interpretation because I spoke or took part in a number of things during the pandemic about whether this or that, whether the pandemic was truly a force majeure or an exceptional event. And, you know, opinions differed, but I think the intention, and certainly the intention during the pandemic, was that it should be treated as an exceptional event or act of force majeure. The question now is, are the conditions of contract and mechanisms dealing with unforeseen and unprecedented events appropriate to deal with the issues arising post-pandemic, and not just pandemic issues, but also some more recent geopolitical issues. Not every issue now is pandemic related, but very many still are. We averted many of the impacts during the pandemic, but what about now? Is it too early to be complacent? What should we be doing right now? So what are the issues post-pandemic? There's a list of issues which I'm sure that everybody watching or in a room will look at and say, yep, I can relate to all of a number of those. So when you get past the protective interim measures provided by governments around the world, when they go, how do parties navigate the post-pandemic events which are not so readily managed by reference to the strict terms of the contract? In existing contracts, these are likely to be affected by all of the reasons you see on this slide. The consequences of the pandemic and other geopolitical influences have to be managed by the parties, or they risk the failure of the project. The key in stress contracts, in my opinion, always has been, and certainly is now, collaboration and agreement to changes which will enable the successful completion of the project. It is the best and it is the cheapest way to get to the end of the road. The temptation is always there to do nothing and effectively leave contractors to struggle or fail, and this simply results in disputes and the projects being abandoned, and that's the worst possible outcome. Effectively, that's sticking your head in the sand and hoping it all goes away. And the pandemic, as we now know very well, did not go away and has left us with a lot of problems going forward. I mentioned FIDIC's golden principles at this point. Through its golden principles and its COVID-19 guidance, which I mentioned a few minutes ago, FIDIC commended all members of the construction community, particularly to keep in mind that FIDIC promotes cooperation and trust between contracting parties, does not support any party taking undue advantage of its bargaining power, discourages adversarial attitudes, and encourages dispute avoidance, and encourages timely and adequate payment in accordance with the contract to maintain cash flow. Now, FIDIC's, although the golden principles were only enshrined in the 2017 forms, these are principles that FIDIC's been advocating for decades. Why then did they suddenly start to work during the pandemic? The NEC standard form contracts, they are rooted in collaboration and mutual trust and cooperation by the parties. And this trust begins at the earliest stage and goes throughout the entire life of the project. It may be that NEC people using NEC contracts are better equipped to manage risks of the sort encountered during the pandemic and during its tailwind than perhaps in other forms, because in part it's a mindset. What are you doing with new contracts post-pandemic and going forward? Where are we going to go with new contracts now? Are all the contracts going to need to be revised or amended? New contracts require very careful drafting going forward, because what was once unforeseen and or unprecedented is not now either unforeseen or unprecedented, certainly insofar as the pandemic is concerned. And also certainly when we look at the extreme weather conditions experiencing, other aspects, other kinds of claims which may have been at once unforeseen or unprecedented are becoming more and more common. And therefore this needs to be reflected in the allocation of risks under the contracts, and it needs to be reflected when they're drafted, rather than when things go horribly wrong and then people have to find a solution to get to the end. It's all happened once, at least once now. The effects are not over, but it can happen again. Parties and professional advisors need to focus on contract drafting to ensure that the risks around these issues can be allocated and managed fairly to ensure a successful outcome for the projects. The principal objective is always to ensure a successful completion of the project within budget and in accordance with the programme. Many of you are engineers, and these words will be indelibly etched on your heart. So let's go to the post-pandemic contractual landscape. How did it do? I asked a question a little while ago. The historic contractual provisions in existing contracts managed a great deal of the impacts, but as I've explained, not without a great deal of collaboration and cooperation by the parties. Parties had to be creative, and in this back to the wall situation, they had no option but to work out the issues, share the burdens, and avert the risk of failure of the project. They had to find fresh ways to avoid or resolve disputes. So the conclusion, the dilemma, keep calm and carry on. It's a wonderful phrase. It was used originally, I think, in wartime. But anyway, keep calm and carry on, or evolve. And I think to evolve on the basis of lessons learned, it is a good way to look at dealing with the future of unforeseen and unprecedented events. What actually did we learn? The thing I think we learned is that if we use our heads and we negotiate and collaborate and compromise and work to secure the primary objective, which is the continuation and completion of the projects, we actually can achieve these things. And the commercial creativity which parties brought to bear during the pandemic should be preserved. It should be applauded. It should not be seen as a sign of weakness, as in the past it often was. And formal contractual mechanisms, what we did learn is that they were not always appropriate to deal with unforeseen and unprecedented contractual impacts. Formal adjudication, formal arbitration, formal litigation were not really much help in these situations, because at the end of the day, all the tribunals and the courts can do is apply the contract. And if you're in a situation where it's not a contractual issue, and it's an obstacle which will prevent the project going forward, you need to find another route. And you can't look to those formal mechanisms of dispute resolution to provide it. So you need to look elsewhere. I mean, mediation is a very good example where you can look for a commercial way to resolve your dispute. Pandemic and post-pandemic disputes, in my opinion, would be better managed and resolved by means other than adjudication arbitration or litigation. And in the current climate, which I feel will continue for quite some time to come, who knows what's around the corner, I commend them to you. Thank you very much.
Thank you, Karen. I think there are some questions from the floor. And let me...
Sorry, I can't hear you.
There are some questions from the floor about what you have just told us. And in fact, for those who are attending, there are, you can raise your questions by this on-site participant by scanning the QR code. But let me put the question to Karen. The first one is, Hong Kong is relatively concentrating on NEC contracts rather than FIDIC contract. And I noted that you have talked about some of these two standard forms in your talk. But the
Sorry,
question...
I can barely hear you. I think I heard you say Hong Kong is fairly concentrated using FIDIC and NEC.
NEC,
and then what?
NEC contracts rather than FIDIC contract.
NEC rather than FIDIC?
Yes, that's Hong Kong atmosphere at the moment.
Yes.
Yes, and the question is, what are the differences, in particular, on the dispute resolution? I think probably the person who raised this question is in relation to the mechanism, and what would be the difference under these two different standard form of contract?
Oh, right, okay. So under the FIDIC, in FIDIC you have clause 21, and you have, well actually I should start a bit earlier. FIDIC, you have the engineer really is the first line of dispute resolution, and the engineer makes a determination as to what he thinks the issue is when an issue is referred to him for determination. If the parties don't like that, they can issue a notice of dissatisfaction, and then they can go to adjudication. Now, the DAAB, the Dispute Avoidance and Adjudication Board under FIDIC, is, the DAAB under FIDIC has two very distinct roles. I mean, they also had them under the 1999 forms, but they were not expressed and articulated in the way that they are expressed in the 2017 forms. And there is a regime, a complicated contract, a procedure, all set out in the FIDIC 2017 form, and the DAB is intended to be there throughout the contract. There's an appointing mechanism to put a DAB in place at the start, and there's a default appointing mechanism, which, as is commonly the case around the world, people don't appoint a DAAB. So the DAAB is brought to the fore, and it has the dual function of trying to avoid the dispute, and if that's not possible, then the dispute may be referred for a formal determination. And there's a procedure to achieve a formal determination. And the way in which the clause is structured is to try and preserve the integrity of the tribunal, so that during the dispute avoidance process, none of the tribunal is compromised. And then if you don't like the decision of the DAB, FIDIC is now very clear that you must pay now and argue later, but you can issue a notice of dissatisfaction, you have a bit of a cooling off period, and then you can give formal notice of arbitration. If you don't issue notices of dispute against the engineer's determination or the DAAB's determination, you're taken to have accepted them, and then you lose the right to go forward to the next step. So it's important to comply with all the notice provisions in FIDIC. Now, NEC has the W options. It has 3 W options. It has the first W1 is where there is no statutory adjudication, and I assume this is probably what you would use in Hong Kong if you wanted to include adjudication in your contract. And then there is W2, which is for jurisdictions where there is statutory adjudication, and you can use that option for those jurisdictions. And then there is W3, when you can have a reference to a dispute adjudication board the decision is not binding, but if you don't like it, you have to say so. And also under NEC3, you have to go through the adjudication process in order to access arbitration. So you have to go through, not like the result, give a notice, and then go to arbitration after that. I think that's sort of a nutshell.
Yeah, I see. Thank you so much, Karen. The next question raised by one of our attendees is that, now talking about unforeseen events from a perspective of law, now if there is a lump sum contract which requires the contractor to construct a plant, and there are some, I use quote if required, and I quote, items in the BQ which are specified but would change with time and other contractors, and not controllable by this contractor, so that they will not be able to make a firm cost estimate at the time of tender. Now, assuming that's the situation. Now, as the situation develops, it incurs significant costs to the contractor. Now, the question raised to you is that in such a case, is the contractor entitled for a claim of variation order, or in NEC concept, compensation event? Have I made the question clear?
Quite possibly, I think. Under NEC, probably more so than under FIDIC. I think you can make a case for a compensation event, but really it's one of those sort of sad-upon questions, you know, as to the precise terms of the tendering, and if required, and how it was dealt with in the tender, and again, records, very important to keep records to justify your claim that the costs were outside what could reasonably have been foreseen. But you do run into the same arguments. You're an experienced contractor. What should you know? What should you assume? And in this kind of obscure situation, I think the answer would be, and it's a lump sum contract, by the way, so it's, in that kind of obscure situation, absolutely imperative to take a long view and to take a very conservative view of what you're being asked possibly to provide, and to make sure that you more than cover your costs. If you're still in a situation after that, then it clearly would fall into the unforeseen, because a reasonable, experienced contractor, you know, couldn't reasonably have foreseen that costs of that nature, costs of that magnitude would have been incurred. So you've got to the first base when you're trying to actually bring the claim. So yes, thanks.
Thank you. Thank you so much, Karen. I see there is no other question from the floor. So I just wish to thank Karen for sharing with us your immense knowledge and experience in this area. So I would invite the attendees to say thank you to you by the usual way of happening. Thank you very much, Karen.
Thank you very much. I really enjoyed talking to you, and as always, it's a great privilege to be invited to speak across the world and to commune with you. I hope in the future we may meet in person.
Thank you so much.